Disability insurance claims for brain malformation. Watch this first. Now, if you've been diagnosed with having a vascular malformation and you can't work, you might qualify for your ERISA disability insurance benefits, but your insurance company or plan may not make it easy for you to get those disability benefits. I will tell you that they generally don't understand conditions like AVMs, cavernous malformations, or even the sequelae of strokes. They'll say, hey, look, your scan looks fine. You worked before, you can work now. Your symptoms are subjective. You've got really depression, and you really are not disabled as a result of this condition. So what do you do to protect yourself? Number one, you document your symptoms that affect your ability to work. Number two, you make sure that your doctor is documenting the objective basis of the diagnosis and the objective basis for restrictions and limitations. That may result in you having to undergo different kinds of testing, including neurocognitive testing if you're having issues with concentration or pace. Now, I think it's also important that you are getting your doctor to complete what's called a residual functional capacity form. Your doctor is asked to complete APS forms in the context of an ERISA disability claim, but as a Social Security lawyer, I know that there are better forms, and we will supplement the APS form with the applicable Social Security disability RFC form. So, for example, we have RFC forms for strokes or for cognitive impairments or for migraines. We want to make sure that your medical records and the APS form is supplemented with a RFC form that will clearly document the extent and nature of your restrictions and limitations so that the disability carrier understands not only the physical impact of your malformation and a sequelae, but also the cognitive impacts. So you need to make sure that you understand that these claims are tough, but they're winnable. And you need to make sure that you, one, understand the disability insurance policy or plan and what you have to prove. Two, you need to make sure that your medical records document objective basis for the diagnosis and restrictions and limitations. Next, you got to make sure that there is a residual functional capacity form or APS form that really explains this. And lastly, you need to understand that there's a good chance that your claim is going to get denied. And if that happens, you'll only have 180 days in which to file an appeal. That appeal is the trial of your case. You can't supplement the file with anything new. You can't wait for your day in court. There won't be a day in court other than maybe a motion for summary judgment. There are no depositions of you. There's no trial. It's decided on the papers. And the judge can only look at what was in your disability claim file at the time of the last denial. So you can see if your claim has been denied or benefits are terminated. It's incumbent upon you to hire an experienced ERISA disability lawyer. Don't wait. The appeal can make or break your case. Got it? 727-894-3188.